Imagine a sitting head of state flown into a Manhattan courthouse in handcuffs. Imagine the United States saying, "This is law enforcement," while governments around the world call it an act of war. What happens in the courtroom when those two stories collide? Today, I'm reconstructing the January 2026 operation that led to Nicolas Maduro's capture, his transfer to Manhattan, and the legal maelstrom that followed. I'll walk step by step through the raid and the chain of custody questions, unpack the SDNY narco-terror indictment and its key elements, forecast the motions and constitutional fights the parties will file, and map the global fallout from frozen assets to congressional war powers inquiries. Quick legal disclaimer, this is an educational legal explainer summarizing public filings, press reports, and expert analysis as of the 8th of January 2026. It is not legal advice. Multiple contemporaneous reports place the operation on the 3rd of January 2026. U.S. forces struck military sites around Caracas while special operations teams conducted a precision raid that led to the capture of President Nicolas Maduro. Reports also indicate his wife was taken into custody. The administration publicly framed this as a law enforcement extraction to bring Maduro to face long-standing narco-terror charges first announced by the Southern District of New York in 2020. At the same time, the operation included kinetic strikes and overseas military movements, actions many states and international law scholars describe as classic uses of force. On the record as of the 8th of January 2026 are the historical SDNY charging documents from 2020 contemporaneous reporting that a superseding indictment was unsealed and that Maduro appeared in federal court in Manhattan, and DOJ and White House statements calling it a law enforcement action with military support. The 2020 DOJ press release remains central. It lays out the alleged narco-terror scheme, identifies co-conspirators, sets out underlying narcotics counts, and explains the narco-terrorism enhancements. When an arrest is made in a warlike operation overseas, are the objects collected, then phones, documents, weapons, treated the same in U.S. court as evidence gathered during a routine DEA takedown in Manhattan? Hold that question for a moment. The original SDNY charges announced in 2020 included narco-terrorism counts, narcotics trafficking, and related conspiracies. In the U.S. context, narco-terrorism typically refers to narcotics offenses that also allege involvement with designated terrorist organizations or violence intended to influence or coerce a government. The SDNY accused Maduro and co-conspirators of participating in an organized narcotics distribution network that allegedly supplied cocaine for distribution into the United States and used proceeds to finance illicit activity. Federal narcotics statutes have been interpreted by courts to reach extraterritorial conduct when the offense has a sufficient nexus to the United States. For example, if the drugs were intended for distribution in the U.S. SDNY's historical approach in transnational narcotics cases frequently asserts extraterritorial jurisdiction and brings cases in Manhattan when criminal acts touch U.S. markets or victims. That is how prosecutors argue they can charge foreign nationals, even heads of state. But the head of state wrinkle changes everything. When the defendant is the sitting president of a foreign state, the defense will invoke sovereign immunity doctrines and international law protections. The million-dollar question becomes, can U.S. courts proceed against a sitting head of state arrested by U.S. forces overseas? The prosecution must not only prove the crimes, it must also prove the court has power to try someone captured in a military operation abroad. Proving that jurisdictional and procedural foundation will shape every subsequent evidentiary fight. Evidence matters in criminal trials. Everything from drug ledgers and emails to phone extractions and biological samples must be authenticated and shown to be reliable to a jury. The January 2026 operation created a complex evidentiary landscape. Some accused conduct dates to investigations that predate 2026. Other material digital devices, documents, weapons were reportedly seized during the kinetic operation. Defense counsel will focus heavily on chain of custody. They will ask when each item was seized, who had access to it, which agencies handled it, whether any gaps or breaks occurred during transfers, whether digital extractions were performed on site or after transport, and whether any evidence was altered or corrupted during strikes. If the defense can show breaks or failures in the chain of custody, it can seek to exclude evidence as unreliable. There is also a Fourth Amendment angle. The defense will argue that the seizures occurred during an unlawful use of force in sovereign territory, meaning any items taken are fruits of an unconstitutional seizure. The government will respond with a multi-pronged strategy: show pre-existing investigative materials and independent sources that predate the January 3 operation, produce chain of custody records and forensic reports explaining processing, and invoke doctrines like inevitable discovery or independent source to argue that even if some evidence was collected during the raid, it would have been discovered lawfully anyway. Digital devices are likely to be pivotal. If the defense can successfully argue those extractions are tainted, much of the prosecution's narrative could collapse. A head of state claim is the headline issue. Under customary international law and U.S. law, sitting heads of state often claim absolute immunity from the jurisdiction of foreign courts. The U.S. Supreme Court has acknowledged limits on immunity for certain acts, distinguishing between sovereign acts and private commercial acts. Defense counsel is likely to argue that Maduro enjoyed absolute immunity at the time of capture and that U.S. courts therefore lack subject matter jurisdiction to proceed. They will press for dismissal on immunity grounds or for the case to be stayed while international remedies are pursued. The prosecution will counter by arguing that the alleged conduct massive narcotics trafficking and narco-terrorism constitutes private criminal acts not protected by sovereign immunity. The government will emphasize public safety and victim protection rationales. EU says courts have sometimes refused immunity defenses where the acts are private and criminal, but no modern federal court has had to resolve an immunity claim where a sitting head of state was physically captured in a U.S. military operation overseas and brought to the United States. That lack of precedent means the SDNY will likely see an immediate, high-stakes battle. If a judge accepts absolute immunity, the case could be dismissed. If immunity is rejected, the case proceeds to extraordinarily complicated evidentiary and jurisdictional litigation. Immunity isn't just binary. The defense may pivot to argue for collateral remedies, suppression, stay, or transfer to international fora. The government must thread a narrow needle, showing that the acts are criminal while justifying the means by which the defendant was taken into custody. Venue fights are both procedural and practical. The defense will likely attack SDNY as an improper forum, under forum non-conveniens, or as a prejudicial venue that cannot guarantee a fair trial given massive publicity and geopolitical implications. Historically, venue has been sustained in SDNY for transnational narcotics cases where substantial contacts with the U.S. exist. But this case is extraordinary. It involves a sitting president, multiple foreign governments criticizing the act, and intense publicity. Classified information will be a major battlefield. Kinetic operations overseas frequently involve intelligence intercepts, signals intelligence, and other classified material. The Classified Information Procedures Act will govern the handling of any classified materials the prosecution seeks to use or disclose. Expect CIPA motions from prosecutors seeking to use redacted or summarized classified information, and expect parallel defense motions demanding disclosure for impeachment or exculpatory purposes. These proceedings often slow cases down and generate interlocutory appellate litigation. Could the classified nature of vital evidence lead to dismissal because prosecutors refuse to disclose intelligence? That is unlikely, but not impossible, is less than zero.